in flux. And over the next 8 days or so, we'll learn a lot about where the court is and where it's going. So let's take a step back and consider how the court got to this present moment. From 1994 through 2005, the Supreme Court had no changes. Justice Breyer was the junior justice for 11 years. Funny story, one of the few responsibilities of the junior justice is cafeteria committee. That's their job. It's supposed to be paying your dues. But over the past 15 years, there have been rapid changes on the court. In 2005 and 6, Chief Justice Rehnquist and Justice O'Connor were replaced by Chief Justice Roberts and Justice Alito. In 2008 and 9, Justices Souter and Stevens were replaced by Justices Sotomayor and Kagan. There was stability for about 7 years. Kagan held the cafeteria duty for a while. Her innovation was frozen yogurt. If you ever go to the Supreme Court, cafeteria, you see frozen yogurt, thank Justice Kagan. But then we had sudden changes. In February 2016, Justice Scalia went on a hunting trip. He did not come home from that hunting trip. He died suddenly in a cabin in West Texas. Almost immediately, as we all know, Senate Republicans said they would not even get a hearing to Judge Merrick Garland, or whoever the nominee happened to be. And the seat remained open through the 2016 election. Had Hillary Clinton won the election, we've had a very different court. But instead, President Trump won the election. And less than a month after his inauguration, President Trump nominated Neil Gorsuch to fill the vacancy. About 18 months later, Justice Kennedy, the swing vote, announced his retirement, and Brett Kavanaugh was nominated to fill the seat. There were not one, but two contentious confirmation hearings, and finally Kavanaugh was confirmed in October of 2018. There was stability for about 2 years as this new Robert Court found its way. In many regards, Chief Justice Roberts became the new swing vote, replacing Justice Kennedy. But we'd have flux one more time. September 18th of 2020, Erev Rosh Hashanah, Justice Ruth Bader Ginsburg died suddenly. 8 days later, September 26th, President Trump nominated Judge Amy Coney Barrett of Indiana to fill the vacancy. Only 38 days before the election. They would not wait until January. Hearings began super fast, October 12th. The committee vote, October 22nd. And was confirmed on October 26th, 8 days before the election. Even that stability will not last long. Justice Breyer will retire any day now. And we'll get a new member of the court, Justice Ketanji Brown Jackson. As it stands now, only one member is left from that court that stemmed from 1994 through 2005. Justice Thomas, who is now the Senior Associate Justice. And that brings us to the present. So what I'd like to do today, the next hour or so, is to look back at the October 2021 term that will conclude in the next 8 days or so, and also look forward to the October 2022 term that will start in about 4 or 5 months. You might have seen Supreme Court roundups before by theme. I did them differently. I did them chronologically. I try to tell you the story of how the term unfolded as it unfolded. It's often said there's been, every term is unlike any before. This truly was a term like no other. So let's start October 1st of 2021. Justice Amy Coney Barrett holds her investiture, which was put on hold because of COVID, for nearly 2 years. She's sworn in as the newest member of the court, officially. Justice Kavanaugh was absent because, like many of you all, he had COVID. But this just sort of set the stage for the term, that they still couldn't all be quite together as they might have liked to. The first Monday in October is by statute when the Supreme Court term begins. October 4th, 2021 was the first in-person oral argument in 18 months. The court, like many of you, went online and they did this sort of teleconference argument, which was not very good, where they went in order. The Chief Justice went, and the Senior Associate, they went in order, and it was very stilted. No one liked it very much. And indeed, one of the justices, I will not name names, flushed a toilet during the middle of an oral argument, so you see where his attention was. Breyer. Sorry, it must be the pollen in the cactus or something. But on October 4th, we get the first oral argument of the year. Mississippi versus Tennessee. This is not an SEC football game. This was an original jurisdiction water case involving groundwater. I will not bore you with the details, but for the first case today, Tennessee won. Go Vols, I suppose. But the next big case occurred about a week later, case number 2 I'll be talking about today, which is Cameron versus EMW Women's Surgical Center. It's an abortion case. No, not that abortion case. We'll get there later. This abortion case involved intervention. Kentucky enacted an abortion law that prohibited a specific method of abortion. Initially, the state defended the law, but then a Democratic governor came to office, and his administration declined to defend the law. The Republican Attorney General tried to intervene, to defend it. The Sixth Circuit said, no, you can't do that, too late, you blew your shot. The Supreme Court ruled by an 8-to-1 vote, 8-to-1, those are not very common, that the intervention was permissible. Justice Alito wrote the majority opinion. He said, it's important to allow states to defend their own laws in federal court. Justice Sotomayor was the lone dissenter, and she warned that the decision will make it easier for government officials to undo litigation decisions of their predecessors. As your state's about to choose a new administration, keep this case in mind. October 13th of 2021, we go from the home of the Kentucky Derby to the home of the Boston Marathon. Of course, I speak of United States against Tsarnaev, our third case. This was the Boston Marathon case. You may remember in 2013, these two brothers, the Tsarnaev brothers, inflicted carnage at the finish line of the Boston Marathon. They killed 3, injured hundreds, and ruined lives that we can't even quantify. During the escape, true story, one of the brothers actually killed the other brother. There was a brother in the car, another brother on the floor, and one brother drove over the other brother. So there's only one defendant. He was convicted of capital murder, many counts in federal court, and the jury sentenced him to death. This trial took a very long time, and I think the trial judge did, as trial judge do, a pretty good job. But the First Circuit disagreed, as appellate judges often do. And the First Circuit said, well, they could have done a better job. The trial judge should have asked the jurors about what media coverage they've seen. Right? You can always second guess that. And the First Circuit said, well, they excluded some evidence about the dead brother. The dead brother was also involved in some separate murders, and the judge excluded that evidence because maybe the jury would have said this other brother could have committed the crime, or the other brother had mitigating evidence, whatever it is, right? That's what appellate judges do. They find little specks. Sorry, justices. The trial judges are all nodding. I can see you all nodding. I clerked in a district court judge in the Sixth Circuit, so I did both angles. I know a little bit how it works. Okay. The court split 6-3 here. Justice Thomas wrote the majority opinion. He said the Sixth Amendment, quote, does not require the jurors know nothing about the case. In other words, the First Circuit applied far too demanding of a standard. And keep in mind, everyone in the world knew about this bombing, right? You could not get a jury pool. In Texas, a venire, right? You could not get a venire of any jury pool that was unaware of this tragedy. Thomas wrote, Tsarnaev committed heinous crimes. The Sixth Amendment nonetheless guaranteed him a fair trial. He received one. Breyer, who's from Boston, wrote the dissent for Kagan and Sotomayor, and he said that the evidence was excluded was critically important, and perhaps the jury could have determined or that the brother's role might have mitigated the defendant's culpability. Okay, but that was a 6-3 case. All right, now we move on to October 17th of 2021. This is not a case I'm talking about, it's a commission. President Biden formed a commission to study the Supreme Court. The origin of this came during the 2020 presidential campaign. There was this sort of drumbeat that we should pack the court, we should expand the court. And President Biden, or candidate Biden, never actually wanted to do this. So I'll tell you what, I'll appoint a committee, right? Now you all know what it means to appoint a committee, right? It's to kill the idea, right? You appoint a committee and you just let it die in committee. That's what committees do, they're very good at that. So Biden appointed about 30 law professors and practitioners and people say the court and retired judges to come together and study how can the court be reformed. And then in October they put out their first report. It was a draft report. It was 200 pages. No, I did not read it, so don't even ask me, but I'll summarize it. On the question whether to add justices, the commissioners were divided. And the committee said the risks of court expansion are considerable. I know your state is experimenting in court expansion, but I'll leave that there. Sorry. Won't get invited back next year, but here I am. I got life tenure. What do you guys? Actually, I have more tenure than you all do, right? I can't get fired. But a proposal that did get some credibility was term limits. Term limits, which had some support from the committee. Now, keep in mind, Biden appointed this committee. And that evening, a reporter asked him, do you support term limits at the Supreme Court? And Biden said no. So from the very outset, he appointed this committee and undercut them right away. The president rejected the idea of whatever this committee was going to come up with. So, that's when I stopped paying attention. Like, this is not going to, but this is a big deal. The president appoints a committee to explore court reform, big deal. All right, that was October 17th. The very next day, October 18th, abortion comes to the Supreme Court. Again, not that abortion case. This one is from my home state of Texas. Texas enacted a law called SB 8, Senate Bill 8, the so-called fetal heartbeat law. This law prohibited abortion at roughly the 6-week mark, when cardiac activity can be detected at an early juncture. As you all know, the current standard as of 9:04 a.m. today is that Roe v. Wade and Casey are the prevailing standards, and you cannot prohibit abortion at 6 weeks. That is well before the point of viability by any metric. Viability is at 23, 24 weeks, depending who you ask. But SB 8 was a unique law. It was not enforced by the government. Rather, private litigants would bring suit against an abortion clinic or someone who facilitates the abortion. That makes it really hard to challenge in court, because you can't sue the governor, you can't sue the attorney general. The statute says these people do not enforce the law. So do you know who the plaintiffs who they sued? You all. They sued the judges. They want to certify a class of every judge in the state of Texas. And not just the judges, your staff. And they want to sue the clerks, literally the clerk of court, to say, I want an injunction saying that the clerk of court cannot even docket, cannot even accept a complaint that brings a cause of action under this statute. Now, usually we say judges have immunity. I'm sure you know this one at least, right? Litigants can't sue judges they're unhappy with. But the trial court ruled that the judges are actually involved in enforcing the law. And that clerks, who I think perform a ministerial function, enforce the law as well. The Fifth Circuit put that ruling on hold, saying, no, you can't sue judges, you can't sue clerks of court. All right? And then this case goes to Supreme Court. It arrives on October 18th. The U.S. Solicitor General brought this case to Supreme Court. The Supreme Court would not decide the case on the so-called shadow docket, right, this emergency docket. Instead, they used what I call the rocket docket, where they accelerated the case on a very fast basis. They set oral arguments for basically 12 days later, November 1st. We'll get there in a minute. But let's talk about the shadow docket for a minute, right? Every court has an emergency docket. You all do, right? In any capital case, judges need to be on call 24/7, right? And I know this state, you've had a couple executions recently. It's part of the law. So the idea of an emergency docket is not novel, right? Every court has it. But what is perhaps unique about the Supreme Court is they decide non-capital cases on this basis, right? There are some cases that come to the court on an emergency basis saying, look, the lower court enjoined the policy nationwide, Supreme Court intervened, or the lower court allowed this law to go into effect, you have to stop it. Over the past couple years, there's been a rampant criticism of the Supreme Court shadow docket, or the emergency docket, as I call it. I think a lot of it's unfair. That's not my topic for here today. But something very important happened on October 29th of 2021. Justice Barrett had given a speech earlier that term in which he said, us judges, we are not partisan hacks. That was a line she used. And she used it. And she said, you know what? If you don't believe us, read the opinion, right? Read the opinions we write for proof. And she sort of hinted that we should not be deciding cases on this emergency basis. Okay? You should not be deciding this. Can we just turn the screen up in front? It's a little distracting. I'm sorry. There's a lot going on the screen in front of me. Thank you. Yeah, the scrolling is distracting. Thank you. So Barrett said, read the opinion. Then on October 29th, the court had a very important vaccine mandate case, where Maine mandated the issuance of vaccines for government employees, and there was no religious exemption. And a number of workers ran to the Supreme Court for emergency relief. The court denied relief by 6-3 vote. Right? Justice Thomas, Alito, and Gorsuch were granted relief, but Barrett and Kavanaugh did not. And Barrett wrote this, I think, important concurrence where she said, look, she was worried that people are using the emergency docket to give these merit rulings on a very short fuse of the benefit briefing. And Barrett basically signaled to the world, okay, you guys, you won, no more shadow docket, right? I'm not going to do it. And by my count, since Justice Barrett's decision in this Maine case, she's basically ruled against applicants in the shadow docket every single time but one. There was one social media case from Texas where Texas tried to regulate social media carriers. She ruled against Texas in that one. But in every other case, she has said nothing on the shadow docket. We are not going to get involved. On to November. November 1st, 2021, the court hears arguments in the SB 8 case, the fetal heartbeat case. And I listened to those arguments. I was actually in West Texas in Lubbock for a presentation. I listened to those live with the students. And, it seemed that Texas was going to lose. Justice Barrett and Kavanaugh seemed inclined to allow a lawsuit to proceed against at least the clerks of court. That is, the clerks are responsible for executing the law. And if you prevent the clerks from even docketing a case, right, you prevent the clerks from docketing a case, the law can't go into effect because you can't sue. You also go to federal court. We can talk about that, right? But you have to enjoin all the state clerks. So I was pretty critical. I was like, how do you sue clerks? That's not a thing. Okay. So it looked as if Texas was going to lose. From abortion to guns, 2 days later, November 3rd of 2021, we have the case New York State Rifle and Pistol Association versus Bruin, B-R-U-E-N. This is the first major Second Amendment case that could be decided in nearly a decade. So some background. In 2008, District of Columbia versus Heller held the Second Amendment protects an individual right to bear arms. And about a year later, we have McDonald v. Chicago, which held that the Second Amendment is incorporated. That is, the Second Amendment restricts the power of the states to regulate guns. Some years later, the court decides a case of New York State Rifle and Pistol versus New York City, which challenged a New York restriction on carry. And this case did not go the way the plaintiffs wanted. The district court upheld New York's gun law. The Second Circuit upheld it. And then as soon as the Supreme Court granted cert, what did New York do? They repealed their law. And they made it impossible to reenact that law. So they mooted the case with like bubble wrap. They just completely wrapped it up with a ribbon saying, please get rid of this case. And the Supreme Court said the case is moot. So then we come back 2 years later, same parties basically, saying we're challenging New York's law altogether. In New York, to conceal carry, you need what's called proper cause or good cause. That is, you must persuade a government official that you have some special justification for a gun. Self-defense is not enough. You have to have something special that does not apply to the population as a whole. This was challenged. Again, the district court upheld it. The Second Circuit upheld it. And the Supreme Court granted cert. This was a very fascinating case from a historical perspective because both sides developed what you might call originalist arguments. They went back to medieval times, literally medieval times, the 1300s. What kind of gun laws were in effect at the time? We talk about laws at the colonial era, laws in the antebellum era, laws throughout the 20th century. In fact, the Sullivan Law issued in New York was enacted in the early 20th century to basically keep guns in the hands of Irish and Italian immigrants. That was the history of the law. So there's a lot of history here that sort of cuts in both ways. But I think lurking in the background was safety, right? Questions were asked, can you require concealed carry on college campuses? And then they asked, of course, is NYU a college campus? Is Columbia a college campus? What about Yankee Stadium? What about the subway, right? Can you require concealed carry in the subway? After the recent shooting in the New York City subway, I'm sure that will make a footnote in one of the opinions somewhere. But after the argument, it looked like the court was going to rule against New York, I just don't know how. That case remains pending. Maybe it'll come down tomorrow. Who knows? Let's go to November 9th of 2021. A death penalty case. Ramirez versus Collier. This is case number 7. Here we have a prisoner who was about to be executed. He wasn't challenging his conviction or even his sentence or the method of execution. Instead, he argued that he wanted his minister to be in the chamber with him when he was being executed, to lay hands on him, basically to touch him, even on his foot, while the protocol is being administered. Texas said we will allow a chaplain, a state-sponsored chaplain in there, but not your private, it was a Baptist, I believe, a private Baptist minister. And so this case was brought under my favorite acronym in all law, RLUIPA, the Religious Land Use and Institutionalized Persons Act, RLUIPA, you're welcome, RLUIPA, it's a great law, which puts a heightened pleading standard on prisons to protect free exercise of religion. Again, this case came to the court on the shadow docket, but the court moved from the shadow docket to the rocket docket. They put it based on argument right away. It still took 4 months to decide, but they argued it the same term. The vote here was 8-1. Chief Justice Roberts was the majority and said, look, we acknowledge that there are safety concerns, that if you have these non-authorized people in the chambers, that things can go wrong, but there are ways you can handle this. For example, let the guy touch his foot. That was apparently okay. What do I know? Justice Thomas dissented, and he said, look, you guys, you got played. He was not sincere, the prisoner. This was just a way to delay his execution. And there's some evidence in the record suggesting he just made up these objections. Do prisoners ever make up objections to delay executions? Does that ever happen? I don't know. But Justice Thomas was very cynical of that fact. And he basically said this is not a sincere objection. But the court was 8-1, and the court didn't see it that way. So I think Thomas was in the minority there. Okay, so now we jump to December, the case you are all patiently, or maybe not patiently, waiting for, which is Dobbs versus Jackson Women's Health Organization. This is the big one, guys. So some history, of course. 1973, Roe versus Wade said that the Constitution protects the right of privacy, which includes the right to terminate a pregnancy. This right shared by the woman and her doctor. About 2 decades later, in Planned Parenthood versus Casey, the court was asked to overrule Roe. They did not. They changed the test. We moved from a trimester framework to this sort of undue burden test of whether restriction imposes an undue burden on abortion, but the Roe standard more or less survived, at least on bumper stickers. Then we come forward about 2 decades to Holman's Health versus Hellerstedt. Right, this is a case from, again, Texas, St. Henry. I'm very busy in Texas. We have lots of cases in my state. Holman's Health versus Hellerstedt, Texas said, okay, fine. We will require doctors before abortions have admitting privileges at hospitals, and also we will require facilities that perform abortions to meet certain surgical standards. The Supreme Court said, no way. Not only are we applying case here, but we're going to expand it, that the courts consider not only whether a law burdens abortion, but does it actually provide a benefit. And the court said, the Texas law provides no benefit. Having admitting privileges doesn't really mean anything, and having the ability to have surgical standards has a minor impact on health standards. All right, but then Justice Kennedy retired. He was replaced by Kavanaugh. 2020, June Medical versus Russo. The court again declines to overrule Roe. And the Chief Justice says, well, in this case, no one asked us to overrule Roe, so I'm not going to do it. So I guess it's a lesson for lawyers to always ask for a lot, because you never want to waive an issue, I suppose. But then we get to June 2022, or 2021, I'm sorry, and the court hears Dobbs. Mississippi enacts a law banning abortion at 15 weeks by any standard that violates Casey and Roe. Right, 15 weeks before the point of viability, even by the most generous standards of neonatal silence. Mississippi, in their cert petition, didn't exactly ask the court to overrule Roe. They kind of hinted at it. But they also filed a cert petition before Justice Ginsburg passed away. Ooh. When the court grants certiorari, Mississippi says, well, now that we got in the court, overrule Roe. Overrule Casey to go full-fledged. So there was actually a question about whether this issue of should it be overruled was properly presented. In fact, the chief, I was re-listening to the argument yesterday on the drive from Phoenix, beautiful drive. I was listening to the argument yesterday on the drive from Phoenix, and the chief was saying, well, did you waive this issue? Did you actually ask about it? So maybe the court says this issue's been waived, but I'll get to that point later. There were nearly 2 hours of argument, which is basically the length of the drive from Phoenix to Tucson. The court was very active. Justice Sotomayor was the most active member of the court, I think, asking questions. I think her most famous line, she said, I'm somewhat paraphrasing, "How will the court survive the stench of overruling Roe? To overrule the precedent of such gravity under such political pressure." But at the arguments, it seemed that there were at least 5, maybe more votes to say Roe was wrong, was decided. The stare decisis factors do not warrant saving it. Let's do it. The Friday after the oral argument, the court holds its conference. I'm sure you all know how this stuff works, right? And at conference, you announce votes. Now, what I'm about to tell you is not exactly a secret, because we have leaked opinion. But at the conference, it seems there were at least 5 votes to overrule Roe. And presumably that's Alito, who had the majority assigned to him, Thomas, Gorsuch, Kavanaugh, Barrett. Now, a vote at conference does not equal a join of the opinion, which I'm sure you all appreciate. The mere fact that 5 members said at conference in November, I vote for the Alito's opinion, does not mean when they actually read the opinion, which we all read, at least I read it, does mean they join it. So I don't put a terrible amount of weight what happened back in November and December. I think it's useful to think about, but as the saying goes, it ain't over till it's over. December 7th, move forward about a week, the Supreme Court puts together its final report, this commission, and they approve it. And they said there's bipartisan support for non-renewable 18-year term limits, but profound disagreement on whether the court should expand beyond 9. Now, I think it's significant, the fact that even a majority of these academics were willing to support court expansion, it was surprising. A decade ago, this would not have been thinkable, right? We've learned from the experience in the 1930s that court packing the Supreme Court is a bad idea. But this idea sort of moved, the Overton window shifted, that is now a mainstream issue. And at some point in your lifetimes, we might actually see an attempt to have 11 justices or 15 justices or 72 justices, whatever the number is, right? You know, at that point it becomes like a mini Congress, which maybe people think of it as. But the fact that so many academics put their brand behind this shift, I think is momentous. And in any other year, a court reform commission would be my top 10 list. It doesn't make my top 10 this year. So it just sort of speaks to how significant it was, right? The report was forgotten almost as soon as it's published. It did not stand a prayer. Speaking of prayer, let's turn to our next case, Carson versus Macon. As you all know, the First Amendment has 2 religion clauses. There's the free exercise clause, and there's the establishment clause. And these are always going to be in tension, right? If the court separates church and state too much, it will probably punish free exercise of religion. If they provide too much protection for free exercise, you might move towards an establishment problem, right? So there's always this conflict. And in the past, the court has said there's a play in the joints, which sort of means, well, to avoid an establishment clause problem, you can sort of limit free exercise of religion, right? The thumb was on the scale of avoiding establishmentarianism. But that was the regime of the Berger and the Warren courts. The Roberts court has been all over the place on some issues, but on religion, they are locked solid. And in 2, and actually now 3 cases decided, they've been basically unapologetic in the direction they're moving. The first was Trinity Lutheran v. Comer. This involved a Christian school that had a playground. They applied for tire scraps for the playground so the kids don't scrape their knees. And the government said, well, we can't give you these scraps because you're a religious school. And the court said, no, you can't do that. Discriminating on the basis of religious status. Right? Decades ago, the court might have held it would be an establishment clause violation to give the scraps to the religious school, but now they're saying you got to give it to them. Then Espinoza, a couple years later, Montana gave these educational credits for people going to private schools, but not religious schools. And they said, oh, our state constitution prohibits it. Oh, that's nice. Court says, no way, 6-3, that you must provide equal funding. You cannot discriminate on the basis of religious status. And the most recent one, Carson against Macon, is from Maine. Maine is a very rural state, there are not a lot of public schools in certain areas. So the government says, if you have an area without any public schools, we'll give you a voucher and go to a private school, but not a religious school. Why did they adopt this policy? To avoid an Establishment Clause violation, right? They were afraid that if they gave vouchers to religious schools, they'd run afoul of the Establishment Clause. Maybe in the 1980s, not today. So this case was argued in December. Justice Kavanaugh was asking, this is just discrimination on the basis of religion. Justice Breyer said, play in the joints, play in the joints. Okay. This case was decided yesterday. I'll come back to it when we get to June. December 10th, we have a ruling in the Texas fetal heartbeat case. Not what any of us expected. I was shocked. So in the case brought by the United States, the court D-I-G, dismissed as improvidently granted. The court said, well, we're not going to decide it. We don't tell you why. It's like Bruno, we just don't talk about it. We'll just get rid of it, right? There we go. I got some parents in the room. Okay, my kids love that movie. Oh, it's just on replay over and over and over again. But on the suit brought by the abortion clinics against the judges and the clerks, this went 5-4 in favor of the state of Texas. Gorsuch had the majority. And Gorsuch said, you can't sue judges, you can't sue clerks. And I think this is the point that this room will get. Judges don't enforce the law, right? You don't. You interpret it, you figure out what it means, but you're not actually executing in any way. To say a clerk of court, by stamping a piece of paper is executing the law, misunderstands what judges do. They're not on any side, right? In fact, the judge in this case said, I can't litigate this case because if I take a position, I have to recuse, right? I'm going to be biased because I've actually litigated. So the judges were really terrible plaintiffs. And clerks, you all have clerks in court, they're just ministerial officers, right? If a complaint comes in, they can't review it. Can you imagine your clerk starts screening complaints based on the content of the complaint? I'm sure they might like that, but that's not how the judiciary works, right? That's not how things work. But the majority said maybe you could sue some licensing officials, like the people who issue medical licenses in Texas. Funny story, Thomas actually dissented on that point, said nope, under state law the licensing officials have no role. This issue was actually certified to the Texas Supreme Court, and our Supreme Court said Thomas was right, that the licensing officials have no role. So basically, God bless them, the Texas Supreme Court overruled the U.S. Supreme Court. Amen. Right, so if you guys ever, if the Arizona Supreme Court finds a way of doing that, you can try it, but it's very rare for that to happen. Chief Justice Roberts dissented. He allowed the suit against the clerks, basically saying someone's got to be sued, right? There has to be a defendant somewhere. And sometimes you draft a law and there's really not a valid defendant. Justice Sotomayor had a very vigorous dissent and she wrote, the clear purpose and actual effect of SB 8 has been to nullify Roe and Casey. But of course, at that point we knew that there were 5 votes to overrule Roe and Casey. So maybe the judges were not so worried about that facet of the case. From abortion to COVID, December 18th of 21, vaccine mandates. So remember back in December of 21, we had the Omicron variant. I have to buff up my Greek alphabet. It's fine. The Omicron variant was raging. And the Biden administration was pushing forward 2 types of vaccine requirements. Or actually, I'll explain a little bit differently. OSHA, the Occupational Safety and Health Administration, said, we consider COVID a threat to workplace safety, so we'll have what's called a vaccine or testing requirement. You either have to get vaccinated or undergo certain types of testing. This was a case called NFIB versus Department of Labor. And then we have the Center for Medicaid and Medicare Services, the CMS, which required that programs that receive CMS funding have to be fully vaccinated. The Fifth Circuit basically said that the OSHA policy was illegal. The Sixth Circuit disagreed, and both cases go to the Supreme Court. And again, the court puts us on the rocket docket for about 3 weeks later. It's an innovation. All right, we'll come back to the OSHA case in a few moments. December 31st, old acquaintance we forgot, right? Happy New Year, everyone. And my favorite part of New Year's, true, is the Chief Justice's message, right? Every year, December 31st, I know I'm a boring person. Every year on December, he's better than Ryan Seacrest, right? Every year on December 31st, the Chief releases a statement. In his own words, it's not signed by the court, it's his own words, kind of his year-end message. Now, a lot of it's ministerial, like your Chief Justice says, here's how many cases we had, here's our docketing numbers, right? Here's our hiring, all these fun things. But then Roberts always puts a little zinger in there. He always sort of just comments on the gestalt, what's going on in the world. And he basically was alluding to saying, get off our backs, right? He says, decisional independence is essential to due process, promoting impartial decision-making free from political or other extraneous influence. So Roberts was saying, if we need help, don't call us, we'll call you. And this, I think, Roberts' dissent to the Supreme Court Reform Commission. All right, December 31st, Happy New Year, everyone. January 7th, the court decides the vaccine mandate cases. And as they often do, they split the difference. They allow the Medicaid, Medicare ruling to go into effect. That is, if you are involved in Medicare and Medicaid services, you have to get vaccinated. But they found that the OSHA rule for but virtually every worker in the United States was illegal. They said that OSHA does not have the power to set broad public health measures. COVID is a risk in many workplaces, but it's the same risk people experience outside the workplace. If you walk down the street or perhaps in the ballroom of the JW Hotel, you're at risk of getting COVID. And then the court said this would significantly expand OSHA's regulatory authority with a clear congressional authorization. Right? In other words, if Congress wanted to give OSHA this power, so there's this broad power that was said so. The metaphor we use is, Congress has not hired elephants in mouse holes, right? This massive power to vaccinate every person in the country virtually would have been given expressly. The dissent was by Breyer, Sotomayor, and Kagan, of course, 6-3. And the dissent said that the court stymies the government's ability to counter the unparalleled threat that COVID poses to our workplace. Right, so the OSHA case went 6-3 against the government. The CMS case went 5-4 in favor of the government. Justice Thomas dissented in the CMS case and said that there's no authorization to impose this requirement. Okay. Now we go January 18th of 2022, a First Amendment case. This is our 12th case of the day for keeping count. Shurtleff versus Boston. Boston City Hall has a very large flagpole outside, and they have a policy whereby they allow public groups to request that their flag be raised alongside the American flag and the Massachusetts flag. Now, according to the record, every single request was granted except for one. A Christian group wanted to fly a flag that had a cross on it. And the city said, no way. Why? Again, the city was worried there'd be an Establishment Clause violation, that if they fly a flag with a cross, there might be a First Amendment problem. So the First Circuit ruled in favor of the city of Boston. Supreme Court reversed 9-0. Not a single vote in favor of this policy. Again, the Supreme Court doesn't agree on a lot, but on free speech there's a pretty broad consensus. And the court said that the flag was not what's called government speech. This was a speech of private groups. Therefore, it's subject to scrutiny. The exact type of scrutiny they did disagree on. Justice Breyer does what he often does. He used what he called a holistic inquiry. Judges love these, right? If you're trying to apply a Supreme Court ruling holistic, you look at history. What would the public believe? How did the government shape the expression? These various nebulous factors, what Justice Alito called a factorized opinion. Kavanaugh wrote a concurrence. He said the government may not treat religious persons, religious organizations, religious speech as second class. This is a theme you're seeing in a lot of the cases. Alito rejected balancing, saying this cannot possibly constitute government speech. Breyer, get over with it. This is not how we do things. Okay, that was 9-0. Let's go to January 19th of 2022. Scandal emerges. There was a leak from the Supreme Court. No, not that leak. That comes later. This leak involves, of all things, masks. Now, we know from the court that Justice Sotomayor was the only member of the court wearing a mask on the bench. She sits next to Justice Gorsuch, who never wore a mask on the bench. I guess he's the Westerner, right, on the court from Colorado. And NPR reports that Sotomayor did not feel safe near Justice Gorsuch. And according to National Public Radio, the Chief Justice asked the other justices to mask up. And they all did, except for Gorsuch. who sits next to Sotomayor. And NPR reports, because of Gorsuch's stubbornness, Sotomayor will not attend the justices' conferences in person, instead joining by telephone. If you don't know, Sotomayor is a diabetic who has what we will call a pre-existing health condition, and she's heightened at risk for problems with COVID. Now, this would be a great story if it was true, but it's not. Later that day, this never happens, a statement was released from Justices Sotomayor and Gorsuch together. They never respond to press leaks, but Sotomayor and Gorsuch had a joint statement saying, "This report surprised us. It is false." The justice said, Nina Totenberg's statement was false. Quote, "While we sometimes disagree about the law, we are warm friends and colleagues." Isn't this good, Chief Justice, right? Collegiality, I think that's one of the words used earlier. This is good, I love this. And then Chief Justice Roberts put out a statement saying, "I did not request Justice Gorsuch or anyone else to wear a mask on the bench." So the story was completely false. NPR stood by their reporting, which tells us that leaks in the Supreme Court happen, and they're not always very good or accurate. All right, let's do a criminal case. Oh, before we get to a criminal case, we have Breyer. Breyer first. January 26th, which was shortly after the leak on the what I call Mask Gate. I think I made that up. It's a terrible name. Mask Gate. We get an announcement. NBC breaking news, right? Justice Breyer will retire. In fact, if you were in D.C. earlier this year, there were these billboards saying Breyer retire being shown around town. So these groups wanted Breyer to step down when Democrats controlled the Senate. And, well, he did. Breyer said, "I have had the great honor of participating as a judge in the effort to maintain our Constitution." Then President Biden made a statement. He said, "I have not made a decision yet who will appoint, but I will nominate someone with extraordinary qualifications, character, experience, and integrity." And he added, "The person will be the first black woman ever nominated to the Supreme Court." So from the outset, President Biden had a sort of idea of who he was going to pick. Now, when will Breyer actually retire? The answer is not clear. We know Breyer is famous for his balancing tests, and we'll get one right here. He says, let me read it to you. Just pay attention, this is good. I intend this decision to take effect when the court rises for the summer recess this year, late June or early July, assuming that by then my successor has been nominated and confirmed. Now, you all know how plea agreements work, right? I intend to do something doesn't mean you're going to do it, because you can revoke your intent. It's not binding. So in my mind, it was never clear Breyer actually said he was going to retire. This is classic Breyer. But this will give us basically 4 new justices in 6 years. We went 11 years with 0 nominations. Now we have 4 in 6 years, which is stunning. I mean, I have whiplash. I have to just sort of spin who's sitting where. You can't remember who's who. All right, February of 22, you got a local case. Arizona versus San Francisco. Now, actually, it's funny, I Googled this case, and it brought up a box score of a Cardinals versus 49ers game. But why the hell is Arizona suing San Francisco? Let me explain. This, of course, right? I mean, this place is very much at odds. This case involves the public charge rule. President Trump tried to impose a rule that said, if you accept public welfare, you are a public charge, a charge in the public dole, so you cannot get a green card. San Francisco and other jurisdictions challenged this. They said it was against the law and arbitrary and capricious, etc. And lower courts put it on hold. Okay. Then the election happens. The Biden administration says, wait a minute, we don't want the public charge rule. We are not going to defend the rule, and we'll just let the lower court's rulings settle. We acquiesce to lower court rulings. And in fact, the Biden administration repealed the Trump rule without notice and comment, citing the lower court rulings, which they declined to appeal. So Arizona and a number of other red states said, whoa, we want to intervene to defend the rule that Biden will not. They appealed, the Ninth Circuit ruled against Arizona, and it was appealed to the U.S. Supreme Court. And actually, your Attorney General, Brnovich, argued it himself. It's pretty rare for the AG to argue a case by himself, but because he wanted the front row seat. He's right there. And Brnovich said that intervention was the only way that the case does not become a blueprint for evading federal law when there's a switch in administrations. I'll give you the outcome. It's not very clear. The court digged the case. They dismissed it as improvidently granted. The court didn't explain why, But the Chief Justice wrote a concurrence for a couple of judges saying that there are procedural complications, right? Did the state have the right to sue? And because of those procedural issues, we call it a vehicle problem, they couldn't decide the case. So in the game of Arizona, the Cardinals 49ers, the Niners won, San Francisco prevailed in this one. All right, February 25th, 1 month after Breyer announces retirement, the president has to make his choice. And there were three prominent candidates that were considered. Justice Leandra Kruger, she's on the California Supreme Court. She clerked for Justice Stevens. Justice Michelle Childs, she was a federal district judge in South Carolina who'd been appointed to the D.C. Circuit. She did not clerk in the Supreme Court. She actually went to a non-elite law school, and she's actually has a pretty remarkable story. I think we'll hear more from her in the future. And then there's Ketanji Brown Jackson, who went to Harvard, and clerked for Justice Breyer. She was a D.C. Circuit judge. Those were the three people most discussed, and President Biden picked Judge Jackson, and he passed over the other two women who might be viable for future vacancies if they so arise. We have then February 28th, West Virginia versus EPA. Okay, this is actually a huge case. It's probably the sleeper case of the term. It involves climate change. Does the executive branch have the power to regulate greenhouse gases based on the Clean Air Act? This case implicates so-called major questions doctrine, this elephant and mouse holes concept, right? If Congress wanted to give the agencies this power to regulate everything, carbon, right, the entire kit and caboodle, they would have said so clearly. They haven't. And there were oral arguments on February 28th. It looks like the government's going to lose this one. I just don't know how far the court will go in major question. The case has not been decided yet. We'll see what happens. The Ketanji Brown Jackson hearings begin March of 21st, about a month after the nomination. Pretty fast, but this is not Barrett speed. The biggest criticism of Jackson was not actually substantive, and I attended about 4 or 5 hours of the hearing. I was in D.C., and I got to say, I thought the hearings were not very good. The biggest thing they were knocking around was their criminal sentences. And I got to tell you, I respect any judges who do criminal sentencing. I respect your job. This is a hard job. You're considering so many factors, and you're looking the man or woman right in their face. I clerked for 2 years, but it wasn't my job to make a sentence. And the knock on Jackson was her sentences were too lenient, especially people involving child pornography and other sort of related offenses. I think she was too soft on them. And look, I mean, maybe her sentences were sort of on the lower end of the there's no guideline, but lower end of the advisory range, but they were not beyond reason. I think a lot of these were just really unfair attacks, so I didn't like it very much. But those are the hearings. It's theater, right? It's theater just to make political points, right? I mean, when you're in the room, you get to see what happens. It's the senators basically time their speeches so they're on primetime TV, and as soon as their time's over, they basically run out of the room and they check their phones. I saw at least one senator literally reading his tweets about him after he finished talking. He's like, oh, look at that, you know. So they're all excited. So it's all theater. I don't put much weight in it. I think Jackson did fine, and she wasn't confirmed. But at the same time that Jackson was on the hot seat, Justice Thomas was in the hospital. Yes, remember this? He had a bacterial infection. You never got a lot of details on it, actually. It's kind of nebulous. He was in the hospital for about a week, and eventually he was released. April 7th, 2022, Judge Jackson was confirmed. Keep in mind, there's no actual vacancy. Breyer's still in the seat. He hasn't resigned yet. And here comes the weird part. Biden gave Jackson a commission. Right? You should get a commission when there's a vacancy. So how do you give a commission to a person who's not actually filling a position yet? And the Office of Legal Counsel, knows more than I do apparently, said, yeah, you can do that, right? Breyer basically retired, it's close enough, whatever, non-pro-tunc will make it work. So Jackson has a commission in her hand. That's basically a worthless piece of paper. But eventually, when Breyer steps down, that commission will just activate the living commission, I suppose, and become a valid document. Whatever. Someone might challenge her as validly appointed. It could happen, but I'm not sure it'll go anywhere. So we will now get our third Justice Jackson. Third? Everyone knows two, right? So there's Robert Jackson, who was the prosecutor at Nuremberg during the Roosevelt years. But also no one knows him. Justice Howell Edmonds Jackson. Howell Edmonds Jackson, a nominee of President Benjamin Harrison. He served from 1893 to 1895. You're welcome. So now there are 3 Justice Jacksons. Be clear when you're speaking up which one. Now, she did have a little bit of flub, though. Judge Jackson said, I am pleased to be the 6th woman nominated to serve in the Supreme Court, the 6th woman. All right, let's count. O'Connor, Ginsburg, Kagan, Sotomayor, right? Jackson. She forgot Harriet Miers. Whoops. Remember Harriet Miers? Yeah, President Bush nominated her. She didn't get a vote, but she was nominated. Okay. April 25th, Kennedy versus Bremerton. This is the Coach Kennedy case. Actually, case number 15 on my list. There's a high school football coach who would say a prayer at the 50-yard line after games. He would not invite students to pray with him. He was speaking. It was not audible. It was a football field. He was fired for leading this, for just saying the prayer at the 50-yard line. Again, the school probably fired him to avoid an establishment clause violation, sensing a pattern, right? They were worried about violating Lee versus Weissman. That could be coercive to have a prayer at a football game because the students might feel compelled to participate. But this case was litigated as a free speech case. And the arguments look like the coach is probably going to win. This case has not been decided yet, but we'll see what happens there. Then April 26th. So far, the term was chugging along nicely. And I kept thinking to myself, I have not seen any evidence of leaks for Dobbs yet. Now, I was on the lookout, and I have experience here, right? In 2012, the Obamacare case was decided, and there was a leak to the Wall Street Journal and other groups saying that the Chief Justice was going wobbly, right? And all these venues have the same message, like, okay, there was a leak, and I confirmed it later with my first book. And then a couple years later, we have the Bostock case involving LGBT discrimination. And around the middle of the term, these op-eds pop up saying, oh, look, Justice Gorsuch is going to vote with the liberals, and Kagan's persuading Gorsuch to move to their side. And I'm like, oh, they got a leak, because whenever you see coordinated reporting on a specific topic, there's something going on. So on April 26th, we get a report from the Wall Street Journal saying, Roberts is trying to pull a justice to the other side to write a narrow opinion. So that, there was a leak. Now, the Wall Street Journal didn't have the opinion that we'll find out next week, but I knew that a leak, and I confirmed it later. They had some insight from the court. So already, information that Roberts was trying to do chicanery was leaking to the outside. I was right. People said, Blackman, you're wrong, all these I get lots of nasty emails, right? But they said, you're wrong, and it turned out the journal had a leak. But then we get to Monday, May 2nd, 2022. This was a big day. In the morning, the court decided Shurtleff versus Boston. This was with the Flag case, 9-0 decision. Cool. In the afternoon, on Monday, they have a memorial for Justice John Paul Stevens, a remarkable human being. He died in 2019 at the age of 99. Do you know he was at the Babe Ruth game where he called the shot at Wrigley Field? He was at that game. Just remarkable. I mean, he met Howard Hughes, Amelia Earhart. He lived through such an amazing life. Just truly, and his memorial was lovely. His clerks had such warm words for him. But I watched it on C-SPAN, and I got to tell you, the justices there, they kind of looked upset. They kind of looked, a little sober. They didn't look too happy to be there. And the reason why is they knew it was about to drop. That evening, Politico leaked. They received, from where we don't know, but they received a draft opinion, 98 pages. Justice Alito's draft 98-page decision. It was dated February of 2022 and was styled as the opinion of the court, which means at least at that point, Alito thought he had 5 votes. Doesn't mean he had 5 votes, but that's what he thought. Now, when I first saw this, I was shocked. Shocked. I couldn't believe it. I was stunned. We've had leaks from the court where rumors speculate and this is going to happen, but an entire 98-page decision published in PDF on a website. And it was a fully formed opinion. It was printed, it looked the way it's supposed to look, it was real. I mean, I had no doubt it was authentic, right? This wasn't a forgery, it was real. And the opinion overruled Roe and Casey. Said those opinions were egregiously wrong. Roe was wrong was decided, must be overruled. Now, there was no concurrences, there were no dissents. We only had the majority, at least as of February. Again, by the time this came out, it was almost 3 months old. So the media's question is, who leaked it? Why'd they leak it? Was it a leak from the left, a leak from the right? We really have no idea. That evening, protests emerged at the Supreme Court. And oh, by the way, the barricades at the Supreme Court, they came up prior to the political story. They knew this was coming because the Politico had asked for comments. So they were ready. And people were basically protesting at the court that evening. The next day, the Chief Justice releases a statement, orders an investigation into the leak. He appoints the marshal of the court to investigate. With respect, that's not her job, right? You know, the marshal sounds like this big figure, but most of what they do is hand out tickets, to argument and make sure the Supreme Court police are walking where they're supposed to be walking. Due to the separation of powers, the FBI was not invited to help. If this was a competent investigation, they would have the FBI do it, but they can't. They don't want the FBI interrogating their staff. And I ask all you this question, would you let your law clerks be polygraphed? Would you let your law clerks have their phones handed over? Is that a public affair, Justice Bullock? I mean, where's the... I mean, what rights of privacy do people have for their phones? Because we know the Supreme Court asked for the phones of every employee to scan where they've been, what they've done, who they've talked to. Now, someone could just put an opinion in the mailbox, old school. But at least at that point, there were still 5 votes to overrule Roe. Justice Thomas gave a speech a few weeks ago where he said that things are different now. And he said you have to look over your shoulder now. Whoever did this, in my mind, was working to destroy the court. That's the only way you do it. This was not designed to persuade you to go one way or the other. It just destroys the court. It breaches a trust. It ruptures a public trust that I don't know can be repaired in our lifetimes. How do you trust anyone? Now, unless this was a foreign hack or someone engaged in some sort of espionage, if this came from inside the building, that someone, a clerk or a staff or someone, or my goodness, a justice, thought this was a good thing to do, I don't know how we recover from the stench. To quote Justice Sotomayor, I don't know how we recover from this. So we'll see who did it. We go from bad to worse. June 7th, 2022. A guy gets in a plane from California. He flies to Maryland. He has a backpack with him. In his backpack, he has a gun, ammunition, pepper spray, zip ties, burglary tools, and boots that are padded so as not to make a sound. A person traveled to Maryland with the intent of killing Justice Kavanaugh in his home. And he said this to the police. He said, I was worried about how Kavanaugh would rule in cases involving guns and abortion. I mean, the irony, right, in gun control cases, but these people are not straight thinking. The person made it to Kavanaugh's house. He knew the address because people put it on the internet, because they've been protesting there for the past 2 months. He walked up to Kavanaugh's door. Thank God he saw 2 marshals and thought better of it. And he basically called the cops and turned himself in. It's actually a good question. For the purpose of an attempted murder, did he actually have substantial step? That's not my topic for today. But we have a session later on threats to judicial independence. We had an almost attempted assassination of a justice. Kavanaugh was home that evening, rather, with his family. He was home. Had those 2 marshals taken a 5-minute break, or maybe had not stayed that evening, this person could have entered the home and killed the justice in his bed while he slept because his feet were padded. When we have all this attacks, the court's illegitimate, When you keep calling something illegitimate, people are not afraid to destroy it. I don't make allusions to the election we just had, but when you keep calling something illegitimate, it's not worthy of protecting. So we had a court packing scheme. I call this the court unpacking scheme, right? The way to remove justices is through assassination, and we cannot lose sight of how dreadful this is. It's a sober topic, because I know you're all here, your families might be here, families might be back home, but people are now viewing the courts as instruments of just these partisan instruments that need to be taken out. All right, I got about 10 minutes left. Let's wrap up. Yesterday, June 21st, so bring us up to speed. There were 5 cases, only one of which, is important, is Carson versus Macon. This was the funding of the schools in Maine. To no one's surprise, it split 6-3. Roberts concluded that you cannot disqualify some private schools because they're religious. This follows from the Espinosa case in Trinity Lutheran. Breyer said, play in the joints, play in the joints. Well, the play in the joints is gone. And the Sotomayor dissent said that we've appended constitutional doctrine, and she's worried where the court will go next. She's making this point that in the past couple of years, there's been a lot of shift since the Kennedy retirement, and she's right. She's 100% correct. All right, where are we now? June 22nd, 2022, today. We'll have opinions tomorrow, June 23rd. I'll expect you all to read them when they come out. And also Friday, June 24th. Next week, we'll probably have opinions on Monday, Wednesday, maybe Thursday or Friday. I think they'll finish before July 1st, but we'll see if they go till the end. So abortion and guns there. So some predictions. If I'm right, call me a prophet. If I'm wrong, forget I ever said anything. That's how this works. There are 13 outstanding cases, not they're outstanding, but there are 13 cases yet to be decided. Some that are kind of boring. Right, for November, we have the New York State rifle case. The only justice who has not written from that sitting is Justice Thomas. They usually try to spread the opinions equally. So I think Thomas has the gun case unless he gave it to someone else, maybe Barrett or somebody else. From December, there are 2 cases outstanding. Dobbs, which is the abortion case, and also Becerra versus Empire Health, a boring Medicaid case, sorry. I won't bore you with it. 2 justices have not yet written, Alito and Kagan. We know Alito was assigned the abortion case, so Kagan probably is the other one. We don't know if Alito still has abortion because the votes might have flipped. Maybe Kavanaugh said, I'll join the Roberts concurrence, so we form plurality, so I don't pretend there's anything solid. From January, 1 case called Conception versus the United States, a sentencing case. Might be Gorsuch or Kavanaugh based on the assignments. From February, we have the West Virginia versus EPA case. This is climate change. I think the chief has that one. He likes to have administrative law. That matters to him quite a bit. A couple cases from March. They're not terribly important. The big one remaining from April is the Coach Kennedy case, and also Biden versus Texas, which involves Remain in Mexico protocols. So the term will end very soon, in about 8 days. I think the abortion case, the gun case, and the Coach Kennedy case are the biggest cases outstanding. Let's look ahead till next year. We had a couple big cases. And I have maybe 3 minutes for Q&A. If you want to line up by there, whoever's a microphone, just go towards the back. I'll take a couple questions. Couple cases for next year. One, Sackett versus EPA on the waters of the United States. What's the proper test? Merritt versus Milligan. This is from Alabama. This is a Section 2 voting rights claim. The biggie, though, Students for Fair Admission versus University of North Carolina, and Students for Fair Admission versus Harvard. This is an affirmative action case of the highest order. The court may actually consider overruling the affirmative action cases from the 1970s, also the 1990s, and the 2000s, which allow affirmative action to pursue compelling interest in diversity. Harvard and UNC adopt policies that objectively make it harder for Asian American students to get in, and these are actually the lead plaintiffs. This is a case where I don't think the universities will win. I just don't know how far the court will go. Another case, keep your eye on 303 Creative versus Alanis. This involves a website designer in Colorado who refuses to make a website for a same-sex marriage. So does she have a free speech right that basically trumps the public accommodations laws? A case that affects probably a lot of people here is ICWA, the Indian Child Welfare Act case. Texas versus Holland, also go Burkine. This is a monster of a case where the Congress has the power under the Indian Commerce Clause to enact laws governing child custody proceedings because the child is an Indian. I don't have to say this too loud in this state in particular. This will have a huge impact on family law. So any family judges in this room should pay close attention to the ICWA decision. Another case from your court, Cruz versus Arizona. Whether the Arizona Supreme Court's holding the Arizona Rule of Criminal Procedure 32.1G precluded post-conviction relief is an adequate and independent state ground law for judgment. Right? In other words, can the Supreme Court rule this case, review it? Is there an AISG? We will find out. And one final administrative law case, SEC versus Cochran. In a dispute between the SEC, can the administrative law judges, can administrative law judges adjudicate cases since they can be removed at will, right? There's one of these ongoing cases without protections. Okay, I am done. Questions? Oh, you can clap, go ahead. Please clap, as they say. But I have 2 minutes for questions, and if there are mics, go for it. If not, just shout out. I can probably hear you. Oh, God, I can't. I'm blinded. I can't see anything. Gabe, calling someone. Yeah, that's it. I can't actually see you all. It's actually it's a myth. I'm actually looking at you. I'm just pivoting my head like a fan. I can't see any of you. You didn't know that, right? It's true. Yeah.
Does the Chief Justice alone have the power to postpone a decision to the next term?
Okay, the question was, can the Chief Justice postpone a decision for the next term? Not by himself. Everything's a Rule 5. So if 4 justices agreed, they could postpone it. There's actually been some talk to dismiss the Dobbs case because it's basically tainted and take another abortion case. But I think that merely prolongs it. And I'll make this point clearly. Every day that goes by, Justice Kavanaugh's life is at risk. I mean, I know the case law is important, but people are trying to kill him to stop him from casting a vote. So I don't think there's a movement to kick it out another year and just extend this this sort of trauma. Other questions? That's it? All right, thank you all so much. Thank you so much for giving us your conference.